Good afternoon, everyone. Thank you very much for joining this, the 7th lecture that we are having in our lecture series, accompanied by the 4 seminars. So the program today is for me to begin by summarizing the last lecture and then answering or responding to any questions or comments that you may have. So if you do have any, please do list them on the chat. I will then complete my discussion, or the lecture rather, on the funding of multilateral institutions, and then we will move on to financing or development. So turning to the 6th lecture, we continued our consideration of the relationship between IFIs and external stakeholders. In many instances, these relationships were defined by contract. We noted that the terms of these contracts needed to reflect the status, privileges, immunities, and exemptions of the IFIs. For example, the price of goods and services under procurement contracts ought to exclude any direct taxes. Similarly, the jurisdictional immunity extended to IFIs needed to be respected, and accordingly, contracts should not provide for any court to resolve disputes arising from the interpretation, application, or enforcement of those contracts. In relation to this last point, we noted that the purpose of jurisdictional immunity was not to avoid IFIs being accountable for their contractual and other obligations to third parties, but rather to manage the resolution of disputes in a predictable manner. Arbitration was the preferred means of IFIs to resolve disputes, partly for all the reasons why arbitration is attractive generally. For instance, disputes can be resolved confidentially. An arbitral tribunal can be composed of persons with specialist knowledge of or sensitivity to the needs of the parties. Unfamiliar and possibly distant courts, whose proceedings may be conducted in an unfamiliar language, may be avoided. The parties needn't subject themselves to potentially several levels of appeal, and the contract may specify the law that the tribunal is to apply. In addition to the benefits of arbitration generally, arbitrating disputes also provides the best prospects of respecting the privileges and immunities provided for under the IFI's charter and possibly other sources. In addition to preserving jurisdictional immunity, arbitration avoids difficult issues that would arise from efforts to compel the attendance of IFI staff, who enjoy functional immunity, to be witnesses before a local court, or for the IFI to produce documents that are protected by archival immunity. However, the immunities enjoyed by IFIs are not unlimited. Typically, once an arbitral award is rendered, then jurisdictional immunity does not extend to enforcement. Again, the purpose here of special treatment for IFIs is driven by the need for disputes to be resolved in a predictable manner, not for contractual and other obligations of the IFIs to be avoided. In our lecture, we noted that there may be instances where the IFI waives its jurisdictional immunity and pursues a claim in court. This may be needed where, in an insolvency proceeding, a court order is required by local law in order to establish a debt. Or it may be that, in relation to financing with a private sector borrower, there is no genuine dispute, but merely a payment failure. In such a case, the IFI may wish to seek a default judgment, which in some circumstances may be more easily enforced than an arbitral award. In our further consideration of engaging with private sector parties, we noted that frequently English law, or often the law of New York, was specified as the governing law of private sector contracts. These laws are widely recognized as supportive of project finance, and their use better facilitates the international syndication of IFI debt to commercial banks. Of course, other developed and settled laws are also sometimes used by lenders generally, but the preference of IFIs is for English and New York law. In our lecture, we also considered the governing law of financing agreements with states and sub-sovereigns. We recalled that agreements between IFIs and states, such as a sovereign loan or sovereign guarantee, were in the nature of treaties. We noted that the UN Charter calls for state parties and parties that are specialized agencies to register international agreements for which there is a simplified and streamlined procedure in relation to agreements of a technical nature, such as those entered into by international financial institutions. The law governing all IFI financing agreements with sovereigns, as well as with sub-sovereigns where there is also a sovereign guarantee, is public international law. This is a necessary implication in the case of the IBRD, but stated expressly in the general conditions applicable to such financings in the case of the EBRD and the AIIB. In the latter two instances, the content of public international law is specified, and this specification draws heavily on the sources of law set out in the statute of the International Court of Justice contained in the UN Charter. To complete our discussion of governing law and dispute resolution, we noted the situation regarding IFI staff, even though they were not external stakeholders of IFIs. The contract of staff, as international civil servants, is governed by the letter of appointment, the internal law of the institution, such as the Code of Conduct and staff directives issued by the President, and general principles of international administrative law, which are derived from the jurisprudence of the leading administrative tribunals, such as those of the United Nations and the International Labour Organization, as well as those of the IMF, World Bank, and several regional development banks. Finally, in relation to our consideration of the relationship between IFIs and external stakeholders, we noted the difficult and uncertain legal terrain of obligations that are owed to non-contractual third parties. And we looked at the role that domestic regulators may have on IFIs. In this respect, we recalled that IFIs are self-regulating, but their policies may voluntarily incorporate aspects of domestic regulation. Domestic regulators were also engaged where IFIs sought to raise funds on the international capital markets or sought to avoid the impact of secondary sanctions. Our sixth lecture then turned to the subject of the funding of multilateral financial institutions. Funds are needed for IFIs for their administrative and capital expenditures and, critically, to support their operational investment activity. These funds may be raised by IFIs for themselves, primarily through issuing capital and borrowings, or by mobilizing funds from third parties to be applied in ways which support IFI activities. We considered the capital structures typical of many IFIs, which involved paid-in capital, callable capital, reserves, and borrowings. We noted that callable capital was not intended to be put at risk, but that it served a useful role in building confidence among creditors, including bondholders. High credit ratings of IFIs enable them to borrow at competitive prices. This is especially true when shareholders' funds are bolstered by significant reserves, typically created by accumulating profits. We noted that at IFIs generally, dividend payments are possible, but there is no tradition of such payments. IFIs could also alienate their capital by making allocations of income to other purposes, with the IBRD routinely using this route to replenish IDA, and with EBRD having allocated income to support special funds that belong to the institution but are separate from its ordinary capital resources. So let me pause there and ask if there are any questions arising out of my summary or of the 6th lecture generally, or indeed of the 3rd seminar, which we held last Friday. So let me ask you to reflect on those various issues and then to just jot down any comments or questions you may have in the chat function. And we can pause here for a few minutes. Thank you. So please do continue to reflect on those issues and to jot down your comments or questions in the chat function. So in our discussion of the funding of multilateral financial institutions, we've now looked at the capital structure. So we've seen that for most of the leading international financial institutions, the capital structure is comprised of paid-in capital and then a much larger amount of callable capital. The idea being that the callable capital will never be called, but is available to cover the losses that an institution might make and which cannot be covered from other sources. So one consequence of this is that a great deal of confidence can be placed in the institution on the part of creditors. And this is particularly so because the callable capital is held by all of the members, but the members that have the largest economies and which potentially have the best capacity to make good on their callable capital calls are represented there. So in addition to the paid-in and callable shares, there is also reserves, and an important part of the reserves usually are the accumulation of profits. So profits can be alienated from the institution or by the payment of dividends, but we've seen that that doesn't really happen, and it can also happen through the allocation of income to other purposes. And we've seen that that has happened in various instances. But the paid-in shares and the accumulated profits constitute an important part of the funding of the multilateral financial institutions, and this is supplemented by another important element, which is borrowings, and that's what we are going to talk about now. So where international organizations borrow, the power to do so is usually provided for in the charter of the institution. However, in some instances, such power may be implied. Fairly early in its history, the United Nations considered borrowing, but ultimately it did not. There is no provision in the Charter for borrowing. However, the view of the UN Legal Council was that such power existed by necessary implication. And that conclusion was reached in part by relying on the authority of the advisory opinion of the International Court of Justice in the reparations for injury case of the late 1940s, a case that we discussed earlier in one of our lectures. Similarly, the International Fund for Agricultural Development also concluded that it has an implied power to borrow, largely along the same reasoning, but of course it was also able to point to a precedent in terms of the conclusion of the UN Legal Council. In both cases, the absence of an express power to borrow can be explained by the expectations at the time of the creation of the institutions that borrowings were unlikely. This was because at the UN, there was no obvious source of reliable income to repay any loans. And at IFAD, the original model for the organization did not accommodate borrowings because the institution was expected merely to match contributions from donors with requests from development country recipients. Now that model has evolved so that now IFAD does borrow and it generates income from that part of its lending that is directed at middle-income countries. So IFAD has a number of borrowings from agencies of the state, particularly, I think the first one was from KfW in Germany, and I think they've also borrowed from the comparable body in another European country, I believe France. So they have not gone to the international capital markets, and the UN did not do that either. But nonetheless, both of them concluded that they can borrow, even though the charters are silent, and indeed IFAD has borrowed. And IFAD has recently obtained a credit rating with a view to entering the international capital markets. But most organizations that do not have a regular income, they rely not on borrowings, but on assessed contributions from members or from replenishments funded by voluntary contributions. And that's the case not only for IFAD, but also for AIIB, which is, as we know, the soft arm window of the World Bank Group. In the case of IFIs, their charters expressly provide them with the power to borrow. Such borrowing is critical for the institutions to pursue their mandates, with borrowing being by far the principal means by which the loans made by IFIs are funded. However, when the IBRD was established, borrowing took on much less significance because it was expected that the IBRD would merely guarantee funds provided to members by third-party lenders. That model eventually gave way to IBRD making direct loans, which were funded by IBRD borrowings. Some borrowings arrive from private placements, as is the case at IFAD, as we noted. However, most borrowings involve raising funds in the international capital markets. This can be achieved competitively because the larger IFIs all have very high credit ratings, partly because of their callable capital structure. An important factor here is the existence of a proportionately large amount of callable capital held primarily by countries with considerable economic power. However, neither IDA or IFC have callable capital, and yet both enjoy the highest possible credit ratings. Other considerations that bear on acquiring a high credit rating include having in place an adequate level of paid-in capital, profitability, and the building up of reserves, clear governance arrangements, a solid management team, and prudential treasury investment and client lending policies. To illustrate the above sources of funding of the institution, we may look at the example of the AIIB. So the Asian Infrastructure Investment Bank has $100 billion of authorized capital. Almost all of this has been issued, although some unissued shares remain available for new members. The authorized capital is made up of $20 billion of paid-in shares, with the balance of $80 billion being in the form of callable shares. So as I said, most of the shares have been issued. So the report of the chief negotiators of the AIIB records the expectation of the founders regarding how shares would be allocated. And in broad terms, the economic strength of applicants would be the principal determinator of the number of shares that would be issued. As we've seen, there are also other shares, in particular the basic shares spread evenly across all the members to ensure that there is some voice. And there's also another small category of shares, which were shares that were issued to the founders to encourage them to join, and it's a form of sweat equity, if you like, whereby all the hard work that they put in negotiating the treaty was rewarded by the allocation of a small number of shares. But the basic way in which shares are allocated is in reflection of the size of the economies of the applicants. And that is the manner in which the shares were allocated to the founding shareholders and reflected in the annex to the Articles of Agreement of the AIIB. And for new shareholders, we do have that principle that was recorded in the report of the chief negotiators that I just described. What happened very quickly is that it became apparent that it was not possible to accommodate all new applicants in a manner that was recorded by the chief negotiators as being the preferred route of allocation. So in respect of the very first additional applicants, if they came from the region, from Asia, the Pacific, then they were given their full allocation. And for members that came from outside of the region, they were given a lesser allocation. But then a year or so later, there were even more applicants, and that arrangement was no longer sustainable. So new applicants ultimately received the bare minimum number of shares sufficient to enable them to become members. And this was so irrespective of the size of their economies and irrespective of whether they were prospective regional members or prospective non-regional members. So the net result is there are a number of members of the AIIB who came to the institution quite late and which have a shareholding that is not reflective of their economic power. But that is the outcome dictated by the need to allocate the remaining unissued shares in a manner that enables all future applicants to be accommodated, even if they cannot get their full allocation. The expectation is that at an appropriate time, there would be a selective capital increase to enable those members to acquire a higher degree of shares that reflects the size of their economy. Of course, if a large prospective member joined, such as Japan, then because of the size of the economy, there would have to be an immediate capital increase, a targeted capital increase at least, to accommodate an applicant with such enormous economic power. So for the AIIB, in addition to having this $20 billion of paid in shares, all of which was paid in cash and all in US dollars, almost $20 billion, then the AIIB has also earned profits. Now, it's earned profits mainly on its treasury book. So this $20 billion has to be invested somewhere. And prior to the onset of the COVID-19 pandemic, then the interest rates were more attractive than they are now. So to date, the AIIB has earned a material profit from its treasury book. But over time, it's expected, of course, that the income will be generated mainly by the lending investments. Now, the profits at the AIIB have accumulated. There has not been a payment of dividend. There has not been an allocation of income to other purposes. So the profits have accumulated in the reserves. And in addition to the paid-in capital and the accumulated profits and the reserves, the AIIB also borrows. And the bank has borrowed on the international capital markets, including having issued a US dollar global bond. The pricing for this has been competitive, partly reflecting the AIIB enjoying the highest rating possible from all three principal rating agencies. And incidentally, this rating has been achieved even though, unlike at the other major IFIs, neither the United States nor Japan are members. So that's an important point, just worth reflecting on a little bit further. So the major IFIs have very good credit ratings. I think that for the IBRD and all of the major regional development banks, they all have AAA ratings. Sometimes there is a downward watch. It's not always a stable outlook, but on the whole, the major IFIs have achieved a AAA rating. They have lost it in the past. The African Development Bank once lost it, but then recovered it. So it doesn't go, it's not automatic that IFIs will have the highest possible rating. And IFAD, which only recently got a rating, has one notch below the highest possible rating. And I think that reflects the fact that it's entirely dependent on replenishments, and there's some element of uncertainty about what the level of replenishments might be from one replenishment period to another. But as a general rule, the major IFIs have the best credit rating. And this is in part explainable by the existence of callable capital. There are other factors, of course, and it's not essential either to the rating. So if one looks at the IFC or one looks at IDA, the capital structure there is different. They don't have callable capital. That's certainly true for the IFC. I believe it's true for IDA. But nonetheless, they enjoy a AAA rating. And for those that do have callable capital, like the other regional development banks and the IBRD, then they leverage off this callable capital and achieve, with the support of other factors also, this AAA rating. And I think part of the reason that they're able to do that is that if you look at the callable capital is held very, very widely, but it includes all of the major economies of the world. And the largest economies hold the largest amounts of callable shares as a general rule. It's not true with China. Even though China is the second largest economy in the world now, it doesn't hold the second largest amount of callable shares at these institutions generally, the IBRD or the EBRD, and others where China is a member. But the largest chunk of the callable capital is held by the countries that have the largest economies. But that's not the case at the AIIB. So the AIIB, as we've noted, does not have the United States as a member, which is the world's largest economy. And it does not have Japan as a member, which is the world's third largest economy. And it does not have one or two other countries which have significant economies, such as Nigeria and Mexico. But I think Nigeria will eventually become a member, and Mexico possibly someday. So even though the AIIB does not have the US and Japan as a member in particular, they still are able to achieve this AAA credit rating. So that's something that's rather special to the AIIB. So we've looked at borrowings, and we now look at those sources of funding which are mobilized by IFIs to support projects. So this is different from the funds that are raised directly by IFIs to support their balance sheet. So IFIs do issue capital, they do accumulate profits in their reserves, they do borrow for their own purposes. And those are the aspects of funding that we have now discussed. We turn now to talk about the funding that is mobilized IFIs that will support projects that the IFIs are promoting, but which reside outside of the ordinary capital of the IFIs. So there are several categories of these. So one is very special to IFIs, and that is the concept of the special fund. Now, a special fund is one whose resources are used to support particular activities of the IFI, often those for which ordinary resources are not appropriate. Now, this might be because the resources are being used to finance irrecoverable expenses associated with projects, such as the cost of project preparation. Or it may be that the funds are being used where the risks involved are too high. And so special funds often absorb first losses of risky projects. The concept of special funds, which we've discussed before, first appeared in the charter of the Asian Development Bank. And this has now been copied by other institutions, including the EBRD and the AIIB. Special funds do not have a separate legal personality from the institutions of which they are part. Accordingly, the institution's status, privileges, immunities, and exemptions apply to special fund resources in the same manner as they apply to the ordinary resources. Many provisions in the charter of the IFIs that have special funds apply equally to all monies of the institution. Critically, these provisions include the rules on competitive procurement. Accordingly, even though special fund resources may frequently trace their origin to donor contributions from members, those members are unable to insist on their procurement rules being adopted by the institution. Because of this, some donors will not contribute to special funds, but rather provide grant funds to the institution in circumstances where ownership does not reside with the institution, and therefore the institution's rules on procurement need not apply. So there's quite a lot in what I just said, but maybe to make it clearer, I can explain the history that led up to this current situation. So at the IBRD, which as we know was really the first of the international financial institutions, the organization took in donor funds to support some activities for which the ordinary capital resources could not be used or could not sensibly be used. And the IBRD still relies on these donor funds, and it has many what they call trust funds. And so the trust funds are there to support the activity of the IFIs, and they're funded by countries wishing to make some contribution. Now, in the early days, most of the contributions that were made by countries were in the nature of tied funding. That is to say that a country would have an amount of money that was available for supporting development. And it might have been that under the domestic law of that country, there's even an obligation to spend a certain amount of the country's wealth or GDP on development. So that's an arrangement that exists today in a number of countries. Several countries have targets for making contributions to development. So then the countries are under some pressure to make sure that these funds are applied, and they will have their bilateral programs. So most countries will have this. So in Japan, you will have JICA, and you will have other agencies of the state as well that can support development. But sometimes this is insufficient, or it's not ideal, and so the countries want to contribute to the efforts of the multilateral organizations. And that makes sense when you think that the larger countries, which are the ones that are most generous in providing donor funds, usually hold the highest shares in the institution. So in the case of Japan, it holds a high percentage of the shares in the ADB, also the IBRD, and so it will also provide a lot of donor funds to those institutions. So in the early days, the countries that were providing donor contributions tied their funding. So they would say, these funds are available for the institution to do something that is agreed upon, but the funds had to be used to finance consultants from that country, or if there were to be grants or of equipment, then the equipment should be procured from that particular country. So this kind of tied procurement was very common early on, and progressively it became less common, and so today it's actually uncommon. And that's partly because studies show that untied funding is much more effective in delivering development. And it's also because the international donor community acknowledges that tied funding ought to be the exception rather than the rule. Now, when the ADB was established, they created this notion of special funds. And the idea of the special funds is that they belonged to the institution, but they were separate from the ordinary capital. And all of the rules in the charter that apply to the institution apply to both the special funds and to the ordinary capital. And that includes the rules that say that there has to be competitive procurement. So in the case of special funds, if a country donates funds to a special fund, it may have some influence over negotiating the terms of its contribution. So in instances where there's a lot of money involved and the donor has a lot of negotiating power, it may be that the institution will set up a new special fund that's particularly dedicated to something which it has an interest in, but which is of particular interest also to the donor. And this has actually given rise to a very large number of special funds across the different institutions. But the trust funds are even more. So the World Bank's trust funds are very many indeed. But the special funds, they necessarily involved competitive procurement. So if a country wanted to make a donation where there was going to be tied funding, then chances are the institution would reject it. But if the institution did accommodate it, then at the AIIB or at those institutions that have followed the AIIB example, like the EBRD or the AIIB, then those funds would not be contributed to the special fund, but they would be held separately in some kind of cooperation funds mechanism or trust fund mechanism. But these are actually quite rare. So the AIIB does not have any of them. The AIIB only has special funds. We refer the AIIB to the special fund, but in fact, technically there are two of them. One provides for paying the costs of preparation for projects in the poorest member countries, and another one subsidizes the interest rates for loans to the poorest countries in relation to their borrowings, which are designed to offset the worst effects of the COVID crisis. Now, special fund resources, they're kept separate from ordinary resources, such as paid-in capital and borrowings. And the losses and liabilities that the special fund generates, they cannot be made whole by the institution's ordinary capital resources. Now, it can work the other way. So special fund resources can be used to meet losses that are generated by ordinary capital resources. But if special funds make losses, they cannot be made whole by the ordinary capital. Now, in addition to being funded by donor contributions, special funds can also be replenished by allocating to them profits generated from the ordinary capital resources. AIIB's special fund resources have been provided by several members. The fund is used, as I said, mainly to help the poorest countries prepare for project proposals, and more recently has been used also to subsidize the interest costs on AIIB loans to poor countries hard hit by the COVID-19 crisis. So that's all I wanted to say on special funds, but just before leaving that, let me just share an anecdote which I think pulls together a number of issues that we've already discussed, including the allocation of income, special funds, payment of dividends, and so forth. At the EBRD, there was a moment when the accumulated profits were substantial. And that was because the AIIB, the EBRD was then and remains now a well-run institution, investing primarily in the private sector. And the private sector, of course, offering opportunities to generate larger profits than what the public sector projects could offer. And that's partly because there is uniform pricing for sovereign projects. So considerable profits were generated. Some of these were because of large gains on a number of equity investments. And then the question became, what should be done with these accumulated profits? And there were a number of different voices. And there was and at one point, the United States was keen on there being a dividend paid, and other countries, a few other countries supported that also. And they wanted to do that because in their view, the purpose of the EBRD was very focused and there were sufficient funds available to pursue that mandate if it was viewed in that narrowly focused manner. And therefore, the accumulated reserves were already surplus to requirements, and so they should be allocated to another purpose, or they should be paid by dividends. And they had argued that the most appropriate route was to pay a dividend. Then there were a group of countries who represented recipients, and they had argued that it was wrong to pay a dividend to all of the members because it was the recipient members who had provided the opportunity for these profits to be generated. It was those recipient countries that hosted the projects in which the EBRD had invested. And therefore, those profits should not be dispersed broadly, but should remain available to the institution to continue to invest in that region. And then there was a third voice, which were not seeking a dividend and which were not recipient countries, but which felt that it was good to maintain the reserves because and this is particularly the case with the Europeans, because the EBRD's mandate was perhaps slightly broader than what the Americans and others had thought. And for those Europeans, they have often thought that the purpose, or a purpose of the EBRD, is to help support the European project. And the European project will be ongoing for some time. The European project being the European Union. And it would be sensible to keep these resources in the institution so that the EBRD retains the flexibility to respond to future needs, whatever, even if they cannot be identified immediately. So that conversation went on for some time, and the compromise solution that was reached was that there would be no dividend paid, but the reserves, those accumulated profits, they would be taken out of the reserves. So the bank would alienate its ordinary capital resources, but it would do that by making an allocation to other purposes, specifically to finance a new special fund, which they call the EBRD Shareholders Special Fund. And the purpose of that special fund was to finance technical assistance and to finance activities which in the past had been particularly reliant on donor funding. So there was another argument, incidentally, why the Europeans thought that a dividend wasn't appropriate, because the Europeans were by far the greatest contributors to the donor funds of the institution. So their argument was, well, a lot of these profits have been generated as a result of all the preparatory work that has been funded by the European countries through their donor contributions. So another reason why it wouldn't be appropriate if all the profits were just distributed evenly among all the members, in proportion, of course, to their capital contributions. So that was the compromise solution, that there was this new special fund, and it still exists and it's very successful. And as it turned out, it was a very prescient move because immediately after this had all been implemented, the financial crisis of 2008, 2009 hit. And one consequence of that is that many countries that had provided donor contributions in the past were no longer in a position to do that. But fortunate, and that I think did result in a number of IFIs suffering as a result of donor contributions having fallen quite dramatically after the crisis. But in the case of the EBRD, the donor contributions also did fall, but that was always expected to fall because of the special fund. But because of the special fund, monies were available to fund those kind of things that donor funds would have funded in the past. And so the EBRD was able to continue with the same program in terms of preparing projects and undertaking the kind of activities that were previously paid for by donors. So just an anecdote for you. So special funds then, it's one important way in which IFIs mobilize funding, which is separate from their ordinary capital resources. Another way in which they do this is by mobilizing commercial co-financing. Now, those funds are usually from commercial banks, and they're not owned by the IFI, and they're provided directly to the project. So IFIs may deploy considerable efforts in mobilizing these funds, because without them, the project may not attract sufficient finance. When co-financing projects involving public tendering by sub-sovereigns, then conflicts may arise over the use of procurement rules, and so these need to be addressed up front, sometimes by agreeing to parallel rather than joint co-financing. So in the IFIs which focus on the private sector, particularly the IFC and the EBRD, but also some of the other regional development banks to some extent, and the private sector arm of the Inter-American Development Bank. In those instances, commercial co-financing is very important. And it's important because the institutions do not finance all of the project costs. So if a sponsor of a project has a proposal, then the institutions are ready to lend, but they will not lend the entire costs of the project. There should be other financing available from other sources in order to share the risk. And there's also a development objective of trying to encourage commercial banks to enter into markets that they might otherwise not have been so keen on because they were unfamiliar or because they had a misplaced perception about the political risks involved. But the main reason is really to alleviate risks. And the IFIs have lots of rules about this, so it's not possible to make an equity investment of 100% in relation to a project proposal. So if the IFI is investing in the private sector, there are rules that normally limit this, typically to about 1/3 of the project costs. If there is an equity investment, the IFI will not want to have a controlling interest. In the EBRD, there is a provision in the charter that prohibits the institution from taking a majority position in an equity investment unless there is a jeopardy situation. In the AIIB, the rule is not expressed so starkly in the charter, but the same sentiment is there. And in the other institutions also, the practice is that they will not seek controlling interest unless it's to protect their investment if something has gone wrong. And in the case of funds, then the general rule is that the institutions will lend probably no more than 1/3, maybe in an extreme case, close to 1/2, but never a majority of the shares. And if I had to guess, I would say it's probably IFIs will invest on average about 1/4 of the capital of a fund. So commercial co-financing becomes phenomenally important for the IFIs working in the private sector in order to deliver on their mandate. And so it's an important part of the organization's work. So at the IFC and the EBRD, there are large dedicated teams that deal with this, and they spend a lot of time engaging commercial banks trying to raise funds. At the EBRD, there's also a specialist unit which administers all of these funds and administers all of these co-financings. And that's a very large job, as you can imagine, because often the commercial co-financiers are looking at the IFI to take a lead in terms of deciding when to enforce remedies or when to provide waivers and so forth. So one particular technique that we have looked at in the past in relation to commercial co-financing is the use of the AIIB loan mechanism. And this was first developed by IFC, but it's also now extensively used by EBRD and to some extent others as well. And AIIB has used this mechanism as well, and I expect that it will use it much more as it implements its corporate strategy, which by the end of this decade should see half of the investments being in the private sector. We've talked about this in the past, but the key point to remember about the AIIB loan mechanism is that it is a means by which the IFI shares its preferred creditor status with the international commercial banks. And it does this by being the lender of record for all of the monies being provided by both itself and the B lenders, and taking charge of the management of all of the funding. So that brings us to the end of the section on the funding of multilateral financial institutions. So I'm going to pause here and invite people to note any comments or raise any questions using the chat function. So we can give ourselves a few minutes to do that. So please do continue to share comments and raise questions, and we can address those going forward. Now I'd like to turn to our next big subject, which is financing for development. So we begin by trying to contextualize the subject, and I think here the politics at the international level have had a real bearing on the subject. So over the past 3 decades, a global view on development has emerged at the political level, with the high points, in my view, being the Earth Summit at Rio de Janeiro in 1992, the Millennium Development Goals of 2000, the 2030 Agenda for Sustainable Development of 2015, and the Paris Agreement on climate change of 2015. Now, in tandem with these, there has been a global recognition that development requires enormous amounts of financing. And this, along with the preferred manner of that financing, has been reflected most significantly in the Monterey Consensus on the Financing for Development of 2002 and the Addis Ababa Action Agenda for Financing for Development of 2015. So all of these events leading to these outcomes have been sponsored by the United Nations, which is really the world's premier development institution. The leading international financial institutions participated in many of these events, particularly the two dealing with financing for development, Monterey and Addis Ababa. This participation was unsurprising given the central role IFIs play in development, the truly global nature of these events, and the close association many of the IFIs have with the United Nations. As we have noted previously, the IBRD, IDA, IFC, and IFAD are all specialized agencies of the UN, and several IFIs, including the Asian Development Bank and the African Development Bank, have UN observer status. As you know, the AIIB also has UN observer status, but this came too late to participate obviously in Monterey, but also in Addis Ababa. Now, the Addis agenda is especially important as it remains current, and it's closely associated with the Sustainable Development Goals. The Addis agenda actually preceded adoption of the Sustainable Development Goals. At the time of the negotiation of the Addis agenda, there were different views among countries on whether the work should be integrated with the SDGs or should remain an independent exercise. Now, the eventual outcome was an independent work product for financing for development, but a product with close textual links to the Sustainable Development Goals. And this linkage was designed to ensure that development financing flows are better aligned with development policy objectives. The Addis agenda was adopted on behalf of all the United Nations members participating. There were 193 of them. That's more or less all of the world. The document identifies more than 100 actions to be taken to support development, including the establishment of a number of mechanisms to facilitate financing and monitor progress. The IFIs are referred to specifically in the document, particularly in relation to the financing of infrastructure development, where, of course, the needs are huge. The G20 also periodically calls on the IFIs to take a lead and catalytic role in financing development. So the Addis agenda is not existing in isolation. So this political context is important for understanding the wider subject of financing for development. And financing and fostering development really takes many forms. Now, much of this support is in the form of loans to sovereigns, or loans to sovereigns with sovereigns providing a guarantee. As we know, this is the exclusive nature of IBRD lending. Other IFIs also engage in this kind of lending, and it is often the most prominent kind of development support. For example, at the African Development Bank or the Asian Development Bank. Now, much IFI support is directed at the private sector. All of the IFC's financial support is in the private sector, and the bulk of EBRDs is too. In addition to loans, IFIs also invest in equity, including funds, and also sometimes issue guarantees to third parties, especially banks. In making loans, the terms usually reflect sound banking principles, quote unquote. which is an express requirement of the EBRD Charter and also of the AIIB Charter, and it's an implied requirement at several other institutions. So sound banking means that if the ordinary capital is to be used to make a loan, then there must be an expectation that the loan will be repaid and that the interest will be sufficient to meet the costs of funding and include a premium for risk. In the case of equity, there must be an expectation that the investment will generate a reasonable return. Sometimes, investment of IFI ordinary capital resources is accompanied by investment of special fund or donor resources. Often, these are grants. This facility enables IFIs to take on more risk than they might otherwise take, and also enables borrowers to absorb less debt than would otherwise be the case. We have seen the example of AIIB using special fund resources supplied by donors to subsidize the interest costs of the least developed countries as they combat the effects of COVID-19. It is also routine for IFIs to use special fund and donor resources to absorb first losses in equity investments or to finance elements of a project through a grant. These forms of concessional financing are familiar to most IFIs, but for several, concessional financing is the mainstay of their business. This is especially true for IDA and IFAD. In the case of IFAD, the majority of its loans are to the poorest countries and are made on so-called highly concessionary terms. These include up to 40 years maturity, a 5 years grace period, no interest, and a modest administrative charge. So this is concessionary lending. Sometimes concessionary funding includes grants. And in the case of IFAD, about 1/3 of the financial support it provides is in the form of grants. In addition to making their own financial facilities available to clients, IFIs often also play a key role in mobilizing financing from third parties. We have already noted the example of special funds and donor contributions. An important part of the business of the IFC and the EBRD, and increasingly at the AIIB, is the mobilizing of commercial sources of financing. We have already discussed joint and parallel financing, as well as the AB loan mechanism. Finally, an important way in which IFIs support the financing of development is by providing policy advice and technical assistance, and by making their accumulated knowledge accessible to others. This is particularly the case at the IBRD, which has more than 75 years of experience in lending and research. So I'm going to shortly try and draw the various threads from this part of the discussion into a section where I will discuss the financing modalities specific to one IFI, namely the AIIB. But I wanted to just pause here for a moment and invite people to ask any questions they may have on the financing for development. So as I said, the political context is very important. I would say that really the two most important documents are the Sustainable Development Goals, because this sets the policy agenda, and also the Addis Action Plan, because this sets the tone for the financing of that development. Not only sets the tone, but it also sets some of the directions, and it has a number of initiatives to help facilitate the financing of development. So the political context is very important. So I'd encourage you to read up on those two documents. The Sustainable Development Goals you are probably already familiar with from other classes, but the Addis Ababa Agenda Action, I think there are 4 A's. Anyhow, this is also an important document, and I encourage you to have a look at that also. So the IFIs, they make their contribution in many different ways. So as we've seen in our previous discussions, and as I've noted now, the IFIs, they make loans to sovereigns. So we talk about sovereign lending. Sometimes it's a direct loan to a sovereign. Sometimes it's to a sub-sovereign, but with a sovereign guarantee. And this is the mainstay of the work of many of the IFIs. It's exclusively what IBRD does. It's also most of the work of the African Development Bank and the Asian Development Bank. Then there's a lot of work that is done in the private sector, and the IFC exclusively invests in the private sector. And in addition, the regional development banks also invest in the private sector, and in the case of the EBRD, it invests mainly in the private sector. So when it's investing, it can invest by making loans, and it can invest by taking equity, and it can take guarantees. But in fact, there's lots of subparts to each of these. So there are loans which might be senior, or they might be subordinated. An example, subordinated lending is quite a common feature of project financing, but there are other forms of subordinated lending as well. And a familiar one to some of the IFIs is to make loans to banks, to local banks that are deeply subordinated, so much so that the local regulators will view the financing as what is known as Tier 2 capital. And so qualifying capital as Tier 2 provides a lot of assistance to those banks, and provides a lot of assistance in terms of their ability to capitalize themselves generally, and to deliver on their operational activities. So many different kinds of loans in the private sector. And then for equity, again, many different kinds of equity. So there can be some pure equity, but there can also be equity where the risks and also potential rewards are limited. So there can be so-called caps and collars on these equity investments. So, and if the cap and collar are exactly the same in an equity investment, which you sometimes see, then even though the legal form is equity, economically it's really a loan. And sometimes equity can be mezzanine, which is to say it has features of equity, but also some features of other instruments. So many different kinds of equity. And then finally, guarantees. There are straightforward guarantees that are provided by the institution. MEGA, part of the World Bank Group, that is its basic business, is to provide guarantees to private sector parties to protect those private parties from certain kinds of political risks. That's what it does. So the other IFIs can do that as well. There are limits. They shouldn't be going into competition with conventional insurers because they are supposed to be additional. They should not be competing with private sector players. Similarly, they should not be in the business of providing export credit support because there are export credit agencies that do that. It's only when the IFIs can do something that is not otherwise being done, or is not otherwise being done to the standard or in the manner that the IFI thinks is appropriate, that the IFI can become engaged. So very many different kinds of financing instruments that are available to the IFIs, even though we sometimes talk about loans, equity, and guarantees. Within those, there are many streams of different kinds of investments and financing support. And in addition to using its own funds, its ordinary capital resources, the IFIs, when they are financing for development, can also use resources that they've mobilized from the official and commercial sectors. So from the official sectors, the loans, the contributions that are made by official donors from countries often will find their way into special funds, but sometimes, as at the World Bank, they find their way into trust funds. And all of these monies can be used to support development. And in the case of the special funds, as we've seen, this can be used to absorb first losses. It can be used to subsidize the interest rate costs. It can be used to support the poorest countries to prepare projects for IFI financing in circumstances where those poor countries don't have much by the way of capacity to prepare these projects. And these special funds can also be used to finance studies. An important study that has existed for many years is the World Bank's Doing Business reports, where they assess the rules and practices existing in every country that is a member and measuring those relative to some international standard. And it can be quite contentious. People often don't like negative ratings, particularly if they're rated more negatively than their neighbor, but a very well-known and useful work product. So that kind of work product is something that can be financed quite easily by trust funds or special funds. The EBRD has an elaborate legal reform project, which is run by its Office of the General Counsel. And that's been going for several decades and is very successful and quite substantial. But this is not in the nature of generating income. So it needs to be funded, and it's really special funds and donor funds that finance that. So in addition to providing direct finance, the IFIs also provide mobilize financing from others. This official funding that I've mentioned, channeled into special funds and donor funds, but also commercial financing. And the commercial lending is very important because without it, the projects probably could not be financed because there are limits to how much the international financial institutions can invest in private sector projects. So as I said, risk is a primary consideration. So risk is to be shared with others, and also just the global amount of investment may be too big. Even if it's good risk, there may be limits to how much an IFI can invest. Sometimes the IFIs are constrained by country limits. So there are circumstances where they'll be compelled to find co-financing, but co-financing is very natural for the IFIs investing in the private sector because they are usually limited in how much they can invest, and they're usually prohibited from taking a controlling interest in equity investments. So, and as an aside, because I haven't mentioned it anywhere else, I don't think, when there is this commercial co-financing, one of the issues that sometimes arises is in relation to procurement. So an IFI will want to impose its procurement rules. A co-financier may have its own procurement rules. That's particularly the case if it is another international financial institution. And the international financial institutions operate together a lot. Their procurement rules are similar, but they're not always identical. But sometimes there is an issue if there is co-financing, because the question becomes whose procurement rules should be applied, which of those two IFIs' procurement rules should be applied. And usually the way that this is resolved is that there is parallel financing rather than joint financing. So if you are financing rolling stock for a railway, then joint financing would be that the two institutions finance the rolling stock together in an indivisible manner. If there is parallel financing, the half of the rolling stock will be financed will be procured using the procurement rules of one of the institutions, and the other half by the other. So if there are differences, it doesn't matter. So a digression, but I wanted to mention that because co-financing can also include parallel co-financing as well as joint co-financing. So then going back to the use of the donor fund resources for those things that don't generate income, a lot of these things are in the nature of technical assistance, but they're also in the nature of knowledge products, including publications. So the transition report of the EBRD or the comparable documents of other institutions, these are usually funded by donor contributions. Not always, sometimes it's the ordinary resources, but sometimes it's donor resources. But all of this underscores how knowledge is very important to the IFIs. They generate a lot of it. They accumulate a lot of it from other sources. They learn a lot from their experiences. So the evaluation function at the institutions is very important so that lessons may be learned from other investments. And all of this knowledge is used not only by the institution, but it's shared with others in different ways. So there are those who say, and I think they may be right, that the principal motivation for countries going to the IBRD is not for financing, but to acquire the knowledge and the expertise that the IBRD, the World Bank Group generally, can provide to help implement, to help design a project, to help implement it. And there is, outside of the IFI world, the depth of this kind of expertise just doesn't really exist. So knowledge is very important, and sharing the knowledge is a very important way in which development is supported by the IFIs, and it's an indirect form of financing. So that's all I wanted to say on the financing for development before launching into the discussion on the AIIB financing modalities. But I think I will save that for tomorrow's class, and I will stop here